Hello everyone. In today's video and in coming videos, I will be covering different kinds of jurisdiction of the Supreme Court. So how many kinds of jurisdiction Supreme Court has? First, it's called the original jurisdiction of the Supreme Court. Second, it's called appellate jurisdiction. Third is called the advisory jurisdiction of the Supreme Court. Fourth is review jurisdiction. Fifth is curative jurisdiction. And sixth is contempt jurisdiction of the Supreme Court. So in today's video, we will be covering the original jurisdiction of the Supreme Court. Now, if you look at this, original jurisdiction of the Supreme Court is divided in two parts. First, under Article 131 of the Constitution and also Article 71 of the Constitution, which is called the exclusive original jurisdiction of the Supreme Court. Second category is called the original concurrent jurisdiction, which is Article 32 and 226. Why it is called concurrent jurisdiction? Because this writ jurisdiction is not only exercised by the Supreme Court, but also it is exercised concurrently by the High Court. So it is original concurrent jurisdiction. So one more thing we need to understand why it is called the original jurisdiction. So original jurisdiction is that jurisdiction where your petition first time originates. It has, etymologically, it has come from origin. So where your petition first time is going to originate, that is called the original jurisdiction. For example, even if you are filing a case before the Central Administrative Tribunal, in that situation, the tribunal is exercising the original jurisdiction. If you are filing a case before RERA Authority, in that situation, RERA Authority is exercising its original jurisdiction. Second thing we need to understand that if you look at any suit which has been filed under Article 131 or 71, that is called an ordinary civil jurisdiction. But when you file a writ petition under Article 32 or 226, that is called extraordinary civil jurisdiction. So what is the difference between ordinary and extraordinary? So please remember, in ordinary jurisdiction, there may be a violation of your legal right. There may be a violation of a statutory right, because that statute may be providing the remedy that if your right or a statutory right has been violated, you can go and file a case here. Then you can immediately go and file a case here in the ordinary circumstances, when there is a violation of right, or then when there is a violation of a statutory right. And please remember, when that statute is providing you the relief, that in which forum you should go. Coming to extraordinary jurisdiction, you may have seen that there is a statute, that a statute is talking about the violation of right, but actually it is not giving you the sufficient relief. Second situation is when there is a violation of fundamental right, or when there is an inherent lack of jurisdiction. In that situation, you want the High Court or the Supreme Court to exercise its extraordinary jurisdiction, which is not exercised in the ordinary circumstances when there is a violation of legal right, or when there is a violation of a statutory right, and when a statute is providing the relief. Now coming back to Article 131, because we are going to start from here. So when you look at Article 131, we have to note down certain very important expressions. It says original jurisdiction of the Supreme Court. It says subject to the provisions of this Constitution. Underline this, subject to the provisions of this Constitution. The Supreme Court shall, to the exclusion of any other court, have original jurisdiction in any dispute between Government of India and one or more state, between the Government of India and any state or state on one side, or one or more states or the other, or between two or more states. But first line says subject to the provision of this Constitution. So what may be the example of this subject to the provisions of this Constitution? First example I would like to give you is Article 262 of the Constitution, which says that Parliament may by law provide adjudication of any dispute in relation to interstate river dispute. So Parliament in its own wisdom has passed one act. It is called the Interstate Water Dispute Act 1956. So if any matter is in relation to the river dispute between two or more states, Supreme Court will not be entertaining the dispute under Article 131. Second example of it is Article 280 of the Constitution. So for example, if there is any dispute in relation to distribution of net proceeds of taxes between one state or the another state, it means any dispute arising out of that will be taken care by the Finance Commission, which is given under Article 280. Third example of this is Article 290 of the Constitution, which says that adjustment in respect of certain expenses and pension. And if any dispute is arising out of that, if you look at the article carefully, it provides that in default of an agreement, it will be determined by an arbitrator appointed by Chief Justice of India. So in that time, arbitrator will be seeing the dispute, even if there is a dispute between the union or the state, or between the state or another state. Next point we need to understand, which this article uses, that in so far as the dispute involves any question in bracket whether of law or fact on which the extent of any legal right depend. So it simply means that if there is a dispute between the union or the state or between two states in relation to any question of fact or any question of law where the existence of or extent of any legal right depends, only in that situation the state or the union can file a civil suit under Article 131 of the Constitution. But what can be the example of that? So the first example which I would like to give you is the state of Rajasthan versus Union of India, which was decided by the Supreme Court in 1977. So the facts of the case were like this. When Janata Dal had into power in the center, the Home Minister of the central government sent letter to the state of Rajasthan, Madhya Pradesh, Punjab, Bihar and Himachal Pradesh and Odisha. And the Home Minister through its letter asked the Chief Minister of those states to dissolve the Legislative Assembly. Now the question was whether that letter which has directed or requested the Chief Minister to dissolve the Legislative Assembly is unconstitutional or not. And then those states which I just talked about, the state of Rajasthan, Madhya Pradesh, Punjab, Bihar, Himachal Pradesh, they filed a suit under Article 131 of the Constitution. Union challenged that suit, stating that it is not maintainable because what is going to be dissolved is the state government, and state government is different from state under Article 131. So Justice Beg, with respect to that, said that no state is not so different from a state government, and we are not going to go to some so technical views. So Justice Beg's opinion held that the petition which was filed under Article 131 is maintainable before the Supreme Court. Second was interesting opinion which was given by Justice Chandrachud, and who stated that when the state questioned the constitutional right of the union government to dissolve the state assemblies on the grounds mentioned in the Home Minister's letters to the Chief Minister as legal and not a political issue, because this was the second objection, that whatever is being raised by those states in the plaint filed under Article 131 is not a legal issue, but it's a political issue. But the Honorable Supreme Court, in the opinion of Justice Chandrachud, held that no, it is not a political issue, it's a legal issue which is a part of Article 131. So the suit which was filed under Article 131 was held to be maintainable. So the next important judgment here which I'm going to discuss is the state of Karnataka versus Union of India. Interesting question in this case was in relation to maintainability of the suit under Article 131, and the question was that when there is a dispute between the union and the state in relation to the competence to pass any law under the 7th schedule of the Constitution, whether that can be considered as an existence of the legal right under Article 131 or not. So what happened that the then Chief Minister of Karnataka, against him there were certain allegations of corruption, favoritism and nepotism. So what opposition party did? Opposition party wrote one memorandum of allegation to the Union Home Minister to conduct inquiry against the Chief Minister. And meanwhile, what happened that the state of Karnataka formed a commission under Commission of Inquiry Act under Section 3, and it started conducting an inquiry against the Chief Minister. After that, when this memorandum of allegation reached the Home Minister, central government also formed one commission under the same section of the same act, under Section 3 of the Commission of Inquiry Act. The state of Karnataka challenged the competence of the parliament to pass this act. So the question was that whether the word inquiry can cover the Commission of Inquiry Act, which is given under List 1, entry number 94, or whether Parliament can exercise its power under entry 97 of List 1, read with Article 248 of the Constitution. So, state of Karnataka filed a suit before the Supreme Court under Article 131. Question arises that whether this suit is maintainable. So, Supreme Court held that this case is maintainable before the Supreme Court under Article 131 because any dispute between the center and the state in relation to the competence of the legislature under 7th schedule falls under the expression which is existence and extent of legal rights. So these are the two very important cases which you must note down. Third important point which you should write down, maintainability of the commercial suit under Article 131. This is an interesting question and which may come in exam. So you just have to focus that even the commercial dispute which may be filed by one state or may be filed by the union can also fall under Article 131 if they are in relation to existence and extent of legal right. So you can connect all these judgments. You can also place the reliance on the judgment which I have just told you and connect with this that merely if dispute is commercial in nature does not deprive the Supreme Court from taking its or exercising its original jurisdiction under Article 131. Second aspect is Article 71 of the Constitution of India. As I told you in the beginning of this video, that original jurisdiction of the Supreme Court is not only confined to Article 131, but it also goes to the extent of Article 71. 71 provides matter relating to election of President and Vice President, read with Part 3 of the President and Vice President Election Act 1952. Again, it has to be read with Order 46 of the Supreme Court rule. So all dispute which are rising out of the election of the President or Vice President, they will also be falling within the ambit of the original jurisdiction of the Supreme Court and will be entertained by the Honorable Supreme Court. Please note down that whenever you discuss about the original jurisdiction of the Supreme Court, you have to read the Supreme Court rules, which start from Order 25 to Order 37. So around there are 12 orders of the Supreme Court rules which cover the original jurisdiction of the Supreme Court. So this is it, and in the next video I will be covering the appellate jurisdiction of the Supreme Court. So till then, see you. Take care.